Okay. Mr. Bolliger?
Yes, good morning, Your Honor. My name is Aldo Bolliger, and I represent the plaintiff. May I reserve 5 minutes for rebuttal, please?
You may.
Thank you. Okay, may it please the court. The facts of this case involve the sale of a defective RV, a recreational vehicle, by the appellee, who is an RV dealer. They have 13 locations nationwide, 3 of them in Florida and 1 in Hillsborough County, where the RV was actually sold. A couple of the most important facts to consider in this case are that the sale took place in multiple sittings. So in the first sittings, various agreements were signed, including a purchase agreement and all the other agreements that appellee relies upon for its Michigan law and venue demands. Then at a subsequent and separate sitting with an F&I person, which I'm sure this court is probably familiar with if anyone's ever attended a car sale transaction, you normally bicker about the price, and thereafter you go meet with an F&I professional in the back, and they have you decide on signing a retail installment contract, which basically then the seller will attempt to assign to a lender, a traditional lender or a bank. So that's exactly what happened here. There was a subsequent and separate sitting where the retail installment contract was signed. The retail installment contract reiterated all the material sales terms in the purchase agreement. When I say that, it has a section that's bolded entitled Sales Agreement, making it clear that it relates to the sale, and it includes all the same itemizations as a purchase agreement has, including the price, the down payment, the pre-delivery fees, the trade-in, the tax, title, tag, gap insurance, and so forth. It then has another section titled and bolded Additional Terms of the Sales Agreement. And in this section, it also makes it clear, obviously, that it relates to the sale, and it contains a mandatory Florida law provision and allows for suit in the venue. This court, when reading the briefs and probably when hearing argument from opposing counsel, is going to hear that this retail installment contract has nothing to do with the sale. It's simply a document between the appellant and a lender. However, if you look at the very top of the retail installment contract, it lists the parties as appellee and appellant, and then it goes on to talk about the sale in these bolded sections and contains all these same material terms. Most importantly, the retail installment contract contains a merger clause stating that it's in the entire agreement and the final expression of the parties. This is also known as an integration clause, and merger clauses call for the application of parole evidence. Now, appellee in this case is a drafter of all these documents. Appellee put the merger clause in there, so appellee ought to be bound by the operation, the legal operation of a merger clause, which means that it's a fully integrated agreement, and therefore you cannot take terms from prior or contemporaneous agreements like the purchase agreement or these other freestanding agreements to vary or alter the final expression of the retail installment contract. The rule of law here and elsewhere is that ordinarily documents executed in a sales transaction are construed together. So unless there's a merger clause, one takes all the documents, looks at them, and then construes them all together. However, when there's a merger clause, then courts are supposed to follow the law of merger, which requires the application of parole evidence. So what should have happened in this case in the trial court should have saw that the allegations of the complaint stated that the retail installment contract was executed subsequently and that it contained a merger clause, and then it should have ignored those prior agreements. There's not even contemporaneous.
You're saying we should completely agree the language, completely disregard the language that they agree to that says if I sign a financing agreement or paperwork, it will be between me and the financing institution. Any paperwork that I sign is not a purchase agreement for the RV, but a financing agreement. Those are merged and that just disappears and we disregard it.
I understand the question, Judge Stargell. Yes, and to respond to that question, that's exactly what a merger clause is for. The merger clause in a retail installment sales contract says you don't look to those agreements. And for that matter, if you want to include agreements like that agreement you just referenced, Your Honor, you have to mention that in the retail installment sales contract.
All right, let's talk about the retail installment contract. So you walk into any place, a furniture store. I mean, they sell tires now on retail installment contracts, rims, anything you do. When you go in there, there's financing companies, and then there's the seller. Those contracts are always going to reference what the transaction is. It's going to include the parties. But your argument is that those two separate transactions, one for the sale and one for, as opposed to a cash buyer who hands the money to them, they sign other paperwork that says this third party is going to provide the funds. That by signing those two agreements, because they cross-reference, even though they're done at a different time and they have this language in there, that those somehow are merged together and you disregard major parts of that agreement. That's what you want us to rule?
Well, I'm not saying that specifically, Your Honor. There's two different things at issue in your question. Number one, it's not like the bank is a third party. The seller in this case extended credit. That's what the retail installment contract does. It's an extension of credit by the seller. The seller then can run around and find a traditional lending institution that will provide the same credit terms as it did. And usually what they do is they find one that provides a lower interest rate so they can keep.
We can't, if we're talking about usually what they do.
Well, in this case, the retail installment contract clearly was between the seller and the buyer. And then at the foot of it, it was assigned by the seller to the bank, and the bank's name was typed in there, correct?
Correct, Your Honor, Bank of the West.
Well, let me ask you, I have a question about the procedural posture of the case, but first, let me ask you a question in terms of that merger. You rely heavily on the Duval Motors case, correct? And General relies on Lowe versus Nissan. So, I mean, we got to figure out which one of these controls. But even looking at Duval has a passage in which it points out that, and they quote, the existence of a merger clause does not per se establish that the integration of the agreement is total if it is highly persuasive evidence or highly persuasive statement that the parties intended the agreement to be totally integrated. Well, in this case, though, can we then look at other evidence of what the parties intended as to the integration clause? And the reason I bring that up is as is in warranty disclaimer form, which seems to say that, well, it doesn't seem to say, it says, even though I may have executed a financing agreement, the purchase agreement with General RV is the only document that contains the terms of my agreement with General RV. Can we look at that document to give us an indication of what the parties intended pursuant to that language in Duval?
You could do that, Your Honor, because you can do one of two things. Because, again, the law is clear. Either you respect the merger clause in the retail installment contract, or if you believe that other documents need to be looked at, you have to construe all the documents together. And if one construes all the documents together, one cannot ignore the retail installment contract completely, because the retail installment contract allows for suit in the venue, and it contains a mandatory Florida law provision. So automatically those provisions conflict with the remainder of the documents, and there's an issue with the conflicts. Now, those conflicts resolve in favor of the appellant, because the appellee was the drafter of these documents.
But if there's a way that we can read those documents separately for the purposes that the lower court found were the intended purposes, one's for financing purposes and one's for the sales purpose, and different transactions, why shouldn't we do that?
Well, number one, I don't believe that's a fair interpretation. When you look at the retail installment contract, it's got highlighted sections stating the exact opposite. It says in there, sales agreement, and it's got another highlighted section saying additional terms regarding the sale. So The plain reading of the document states the opposite. Moreover,
well, and indeed, the concern I have with the judge's finding that these documents totally address separate transaction. One, the sale; the other, the financing. This is the retail installment contract contains this sentence: "Seller will not make any repairs or additions to the vehicle except as noted in the description of the property section." Well, how did that have to do with the financing?
Right, and there's a lot of things like that in the retail installment contract.
Well, I didn't find a lot of things like that, but there's that. What the judge said in the order is not exactly true. It's not exactly consistent with the documents here.
Right. The trial court followed the appellee's argument, and that's what the appellee argued. However, there's another section in the retail installment contract that itemizes a $499 charge that's not even listed in the purchase agreement. So one cannot just ignore the retail installment contract. What the trial court then did is then it applied the case of Lowe v. Nissan of Brandon for the proposition that you can, on one hand, have a purchase agreement, on the other hand, have a retail installment contract. However, those facts are so different than the facts in this case that I don't think it was proper, because the number one thing that this court did, and I believe Judge Northcutt, you sat on that opinion. You didn't write the opinion, but you sat on that case. The court started off its opinion stating that there's no evidence as to the order in which the documents were signed. So it started with that, and then on top of it, it also went into, in that case, the purchase agreement was required because the plaintiff in that case could only prove his case through the purchase agreement. So the plaintiff couldn't distance himself from the purchase agreement. Then there were another couple of different contingencies that don't apply in this case. So it looks to me, and I don't want to obviously put words in the court's mouth, but it looks to me that these facts are nowhere near the same facts in this case. And if one follows appellee's logic, you're now making a bright line rule that in any case, a purchase agreement is going to control over a retail installment contract. And that's just not how the law works. That's not how the law works.
Let's go back to a minute ago. You said there was an additional fee that wasn't included.
Yes.
Doesn't that point to there being separate agreements as opposed to it just being pointing to the other agreement?
Well, I think what that evidence is, Your Honor, is that you cannot say that the purchase agreement only involves the sale when they're using the retail installment contract to collect a pre-delivery purchase fee out of that. That obviously is a sales term. You have that.
Yeah, I think your point was that the court's observation that the two agreements addressed entirely separate transaction wasn't exactly true. The retail installment contract, because that fee was for stuff that the dealer would do, correct? It was as it says, cost and profit to the dealer for items such as inspection, cleaning, and adjusting the vehicles and preparing the documents related to the sale. So that was again a charge that wasn't strictly related to the financing, but it was included in the amount that was financed, because it also said that fee could be paid in cash or it could be included in the financing amount.
And that's going back to my question, Mr. Bollinger. Doesn't that evidence that there's two different kinds of people who might be buying an RV? The kind of people who have saved up for years and are handing over money to the dealer. And then there's the people who are going to finance it, all or part of it. But a fee that's for the dealer to service or to do other things, that's going to be paid whether you finance it or not. Correct?
Correct, Your Honor. Yes. Yes.
So doesn't that evidence that part of it's financing and part of it's a purchase agreement?
Well, there are compelling arguments, but the plain reading of the document states that it applies at the sale. Moreover, if you're going to include a sales term that's going to be profit to the dealer that only is listed in the retail installment contract, I think it proves the opposite, Your Honor.
How much does one read into the retail installment contract where it has a caption or a title that says sales agreement, and the first words read like a promissory note? You promise to pay. and then later on you provide a security interest in the collateral. Does the caption, because it's captioned sales agreement, make it a sales agreement, or do the language, you promise to pay, make it a promissory note, in effect, a promise to pay, and that's all?
Well, I think it does both, Your Honor, because I think sales agreement, if it has nothing to do with a sale, you don't need something saying sales agreement. And then a couple of pages later, it says additional terms of the sales agreement, and it's got a litany, a whole half page of maybe 6-point font terms that are all related to the sale, have nothing to do with financing. This transaction can survive with only having a retail installment sales contract. One doesn't need a purchase agreement. You can go into a dealer, arrive at a figure for the sale and the terms, and then the dealer just give you a retail installment contract. However, it can't do the inverse. This transaction does not survive on only a purchase agreement, because the seller extended credit to finance the transaction. And even though it assigned the contract right away, there was no reason that the lender in this case, or the financial institution, had to accept that assignment. These assignments go bad months after, because there's arguments over whether it's going to be assigned with or without recourse. They don't like the credit rating of the person that's on the retail installment contract. So this transaction can only take place if you have a retail installment sales contract and not the other way around. It's the most important document. And not only that, but plaintiff specifically attached it to its complaint and sued thereunder because plaintiff is revoking acceptance. So if one were to only revoke acceptance on the purchase agreement, there's no way to cancel the financial obligation, and revocation would be incomplete. So again, one cannot ignore the retail installment contract. So either the trial court could have found that it didn't need to look at parole evidence, it could construe all the documents together, or it could have followed the merger clause and then just ignored the purchase agreement. But it can't just ignore the retail installment contract and say, we're now going to say there's two separate transactions. It's only one.
Well, but that was my point. If the court is going to construe all the documents together, isn't then the statement in the as-is/warranty waiver form pretty indicative of the party's intent that only the purchase agreement is the controlling agreement between the purchaser and General?
Well, they can make the statement that the purchase agreement is the only controlling agreement, but the law, TILA, the Truth in Lending Act, says you have to have a retail installment sales contract if you provide financing in the transaction. I
get that. But whatever the law says that you have to have the Truth in Lending form and all that, but it doesn't say that it can't have, that it must override choice of form provision in the purchase contract.
Right. I get the point, Your Honor, but you're still going to have a conflict because the retail installment contract states Florida law and allows for venue here. And how are you going to revoke acceptance? I shouldn't be answering these.
Well, what I'm saying is that if there's any ambiguity about whether the installment contract is also a sales contract, isn't that cleared up by the statement in the as-is/warranty waiver form that says no, even if we sign financing documents, the contract that controls our purchases is the purchase agreement?
I don't agree with that, respectfully, Your Honor. And number one, that's exactly what the merger clause is for. All Appley would have had to do is not put a merger clause in a retail installment contract, but it put it there for a reason. And obviously, it's a master of these documents. He created and drafted them all, and that was the last document signed. So again, the law says that you're supposed to follow what the merger clause is. It's the party's intent to apply parole evidence. So all they're trying to do is vary this document, the retail installment contract, with these superfluous and prior statements. And again, they shoehorned it. They're calling this as two separate transactions. That's just not the case. It's only one transaction. It's a finance sale transaction. And I also quoted Florida Statute 520 because that's what they call it, a finance sale transaction. It's one transaction, not two transactions. And not only that, but if we get past all the merger clause and all these issues, a big part of the case below was that I argued that the venue provision is unenforceable because it deprives the appellant's day in court. It's unfair and unreasonable and unjust and a product of overreaching. I supplied an affidavit from my client. It sets forth that the RV is here in the venue. It's not drivable. It can't be taken up to Michigan. So that's the single most important piece of evidence. Moreover, there's at least three people just in the sale of the RV that are key witnesses that you can't compel to Michigan. Then there's at least a half dozen or more witnesses that conducted a year's worth of repairs. All these witnesses you can't compel to Michigan, and basically the law that applies here is the 11th Circuit case, the U.S. Supreme Court case, and the Florida Supreme Court case that say in a business, a sophisticated business versus a consumer transaction, the law is different than in a corporation-to-corporation transaction where one is attempting to enforce a venue provision. Now, I acknowledge venue provisions are contractual terms. They ought to be enforced in most cases. And all the law that the trial court looked at and all the law that you're going to hear from Appellee are business-to-business transactions where you have a legally sophisticated corporation contracting with another legally sophisticated corporation for venue somewhere. In those cases, almost without exception, the venue provisions are upheld. However, the cases that I briefed that ought to be controlling this transaction is when you have a take it or leave it pre-printed adhesion type of contract that you give to a consumer that can't appreciate these things, that courts ought to look behind it to make sure that you're not forcing somebody into legal Siberia to litigate a case.
And in this case, the judge didn't expressly rule on that issue, but cited the what's the name of the federal case that the Carrig. So I guess indirectly the court rejected that position, correct?
Well, I don't think the court even looked at it because that order.
Well, the court cited Carrig, which had to do with that issue.
Well, it had to do with that issue, but it only
guided by it. All right. But you're right at the end of you're right coming into your 5-minute rebuttal time, Mr. Bollinger. But I want to raise, and I won't charge you with this, I want to raise a couple of procedural questions. Let me see if I can find my notes here. First of all, it's not clear to me actually that this order is final and appealable as such. I mean, the initial order just granted a motion to dismiss and didn't actually dismiss. And then the clarification order it says, and dismissal of this defendant is with prejudice. So I will grant that possibly that made the order final for purposes of our jurisdiction. But that raises another question. I mean, and that issue can be, if we conclude that this isn't a final order and that didn't cure that, that's easily taken care of. Concern I have is that the dismissal is with prejudice. Is that deemed to be a ruling on the merits for could your client then go to Michigan and file the lawsuit against General that seems to be contemplated here?
I believe that my client could go to Michigan and file a lawsuit, but
even though there's a dismissal of its suit against General with prejudice?
Well, it's with prejudice in Florida, and it's upon the ground being the venue. It was incorrect. So
well, I know what the ground is, and it seems to me that the proper language would have been dismissed without prejudice to refile in Michigan.
I agree. That's probably the better language that should have been included in that order. I do believe it's a final order when it says with prejudice because it stops a plaintiff from being able to bring a case here at all in the state of Florida. The only way you can bring a case now would be to bring it in Michigan.
Gotcha. Get it. All right.
All right.
Well, you want to say the rest of your time for rebuttal, I assume. All right.
Thank you.
Mr. Schwartz, welcome to Florida, although I assume you're not actually in Florida.
No, it feels like Florida here, though. It's finally nice.
Okay. We should have done this in the winter,
May it please the court. Nicholas Schwartz on behalf of the appellee in this matter. I think it's really important to this case that we take a look in detail at the facts of the case. It's a very fact-intensive case, and the facts, in the end, favor our position. So Mr. Rubio Benavides came to General RV to purchase a new 2020 Maybach RV from General RV. He signed a purchase agreement, all the other documents, the finance agreement on 11/9/19. All of this was done that same day. The RV itself was assembled by a company called Nexus RV. Nexus RV expressly warranted the RV. So I only mention this because if there are warranty issues, the appellant has recourse against the warrantor, not against General RV. However,
yeah, but this is a Magnuson Moss suit where he does have recourse against the seller, correct? He can
not if the warranties are all disclaimed. There's no
okay.
warranties.
Is this the basis of your motion to dismiss? Aren't we getting outside
nope. It is not the basis of the motion.
Okay, so let's confine ourselves, because that might be a basis for a motion for summary judgment or whatever.
Fair
but
enough.
You know, we're confined to the four corners of the complaint and the motion to dismiss, and you know.
Fair enough. But then we get into the documents that the appellant signed. So we have the purchase agreement, and the purchase agreement differs greatly from that in the agreement in Duval, which the plaintiff relies on. In this agreement, we have a merger clause. This purchase agreement contains the entire understanding between General RV and purchaser. And then that is on the front of the contract, immediately above the purchaser's signature. It also reads, by signing below, purchaser acknowledges that purchaser has received a copy of this agreement and that purchaser has read and understands the terms of this agreement, including those printed on the reverse side, which include an as-is clause, a non-refundable deposit statement, and a choice of law and forum selection clauses indicating that Michigan law applies to all potential disputes and that all claims must be filed in Michigan. Then on the reverse side of that contract is paragraph 2, which reads, purchaser agrees that the exclusive jurisdiction for deciding any dispute shall be in Oakland County, Michigan, and purchaser will file any claim in Oakland County, Michigan.
But doesn't that just beg the question of, you know, because you haven't gotten to the retail installment contracts merger provision, doesn't that beg the question of whether anything in that purchase agreement is binding at this point? You know, I mean, you know, it's the plaintiff's assertion that the merger provision in the retail installment contract made that contract the operative one.
So, and that's where you look
and I mean, that's kind of what this case boils down to, correct?
Correct. And then, so then you look at that as is disclaimer form. And first, that also furthers that all claims must be filed in Oakland County, Michigan. But then you have that paragraph, relationship to the financing agreement. If I sign any financing agreement or paperwork, it will ultimately be between me and the financing institution. Any financing paperwork that I sign is not a purchase agreement for the RV, but a financing agreement. The only purchase agreement that I have with General RV is the two-sided document entitled Purchase Agreement regarding the RV. It disclaims all warranties and contains an as-is choice of law / forum clauses. And I think that resolves everything. Now we have this clear definition of the role of each document. So we have a purchase agreement that governs the purchase of the RV. And in fact, the plaintiff or the purchaser can buy the RV without ever signing a retail installment contract. Once he signs that purchase agreement, he's obliged to buy the RV for the agreed upon price from General RV. Whether or not he obtains financing, it doesn't matter. He could.
That's all well and good, but then he proceeded to sign a retail installment contract that suggests their assertion is that then became the operative contract.
So if you look at the retail installment contract, and someone had mentioned this, it specifically talks about the obligations. The obligation is and it reads, you promise to pay us the principal amount of $133,326.05 plus finance charges accruing on the unpaid balance at the rate of 6.75% per year from the date of this contract until paid in full. That's the agreement. Now, it
also includes some other terms, and maybe you can clarify for me whether it really has any bearing on the case that the order that the judge signed, I don't know if the judge wrote it, that says that the retail installment contract only related to the financing was not exactly accurate, because it does say the seller will not make any repairs or additions to the vehicle except as noted in the description of property in the retail installment contract. That doesn't seem to relate to financing.
Well, so it's not just a retail installment contract, it's also a security agreement. And that has to do with the security. The bank needs to protect its security. Its security is this RV. And it wants to make...
But here's the thing. The bank's not a party to this contract.
The bank's not a party to which contract?
The retail installment contract.
The bank is ultimately the party to the retail installment.
It's an assignee, ultimately.
Correct.
But at the time it's executed, and the seller, as referenced there, is not the bank. Correct?
Right. That's correct. The General RV initially signs the retail installment contract, then immediately assigns it to the bank. This isn't an instance where Mr. Rubio Benavides decides to buy an RV, General RV sells it to him, and then goes and finds financing.
Right, and even though the brief on your side kept arguing that retail installment contract was strictly between the plaintiff and the bank, that's not true, is it? This is a retail installment contract which is between the seller and the purchaser, and then it was assigned. That's how those things typically work.
If you're talking about how it typically works, it would typically not be assigned until seconds after.
Seconds after, or
right.
Even the next day. There's no limitation. But typically, you're right. It's all done. But the agreement is not between the buyer and the bank. The agreement's the buyer and the seller assigns it. That's a retail installment contract.
That is correct.
Your brief's assertion that it's really between the seller and the bank, that is not true.
No, I think it still is true. It
becomes true once it's assigned, but in
right.
terms of whether this agreement was really the governing operative agreement for the purchase, that argument is not true. This is actually between the buyer and the seller.
So like you said, yes, it is.
I think I've gotten us confused here, but
well, it is it's between General RV and Mr. Rubio Benavides.
Right.
But as that document is being completed, the agreement has already been made to assign it. Mr. Rubio Benavides already has approval from, in this case, Bank of the West, which is required.
The seller has obtained the approval because the buyer hasn't gone to the bank and applied for a loan and then taken the proceeds of that loan and bought the RV. Correct? Well, the seller has qualified the buyer. I mean, that's what you're doing in the finance office at these dealers. So the buyer meets the requirements of the bank, and the bank, says okay, and then they assign it. So that's how retail installment contracts work.
The way is that the case, or I'm not saying, because that's an important question I have to. Is that the case, or is it that the bank has approved them, and that? Well,
what I'm saying is the bank may well have told the seller that this buyer is approved, but the retail installment contract, when executed, is not between the seller and the bank. So, the buyer and the bank. It's between the buyer and the seller then assigns it to the bank. And that may well have been preordained, of course.
Correct.
But in terms of the legal responsibilities, that, until that assignment is made, the only two people on the hook for this agreement are the buyer and the seller.
But my question, just for him to answer, is when they go into the showroom and they're sitting there do they know, because I know there's language in here about, if they don't come through with the purchase price, if they don't qualify, they know they're dealing with X institution, Bank of the West, and that they've been approved by Bank of the West, correct?
When they walk in the door, obviously they don't. But
no,
before they
sign the paperwork,
before entering into any of the agreements, they would know what the seller would be approved for. So in this instance,
what the point is, though, is that the buyer does not sign a note to Bank of West, correct? It signs a retail installment contract that is then assigned to Bank of West.
Correct. But the buyer also submits a credit application.
Of course.
Right.
And
yes.
Is that credit application
the seller isn't bound,
General RV, or is that to Bank of the West?
I'm sorry.
Go ahead. We talked over each other.
Yeah, I'm sorry. What was the question?
I was going to say the seller, I'm claiming seniority here. Judge Stargill is claiming juniority. But the seller is not bound by any document here to assign this to the Bank of West. It could assign it to any other bank that it has this kind of relationship with, and the buyer has nothing to say about it. Correct?
Well, not
there's
totally.
There's no contractual obligation to assign to a particular lender.
That's correct, but the buyer would have to obtain approval for the financing. So it's not like Mr. Rubio Benavides could submit an application to Bank of the West, and then General RV could just go assign it to Bank of America or whoever it may be.
Well, we don't. I don't know if we have those facts in our record,
Right.
But what we do know typically is that he fills out an application usually right there at the dealer, and then the dealer shops it around for the financing. Now they may have already known that it's going to be Bank of the West just because that's what they do, but there's nothing in the contract that says that.
There's nothing in
in fact, Bank of West is
the retail installment.
Right. In fact, the assignment form on the retail installment contract, Bank of West is typed in. It could have been First National Bank. It could have been Barnett. Could have been whoever. And still be within the terms of the agreement between the buyer and the seller.
That is correct. If I'm understanding you, yes.
Yeah. You're up, Mr. Judge Stargill, junior judge.
Okay. So when Mr. Benavides would have come in there, kicked the tires on his RV, figured out what's going on, he fills out an application. Is that application one that is for a retail installment contract with General RV, or is that an application to Bank of the West, as opposed to, okay, we think you're fine, and then we're going to eventually sell your paperwork? When he sits down and signs the paperwork, he knows he's been approved by X institution, in this case, Bank of the West, and then signs all of these documents that say, I understand the financing isn't with you, and for these purposes, I'm dealing with Bank of the West. Is that an accurate depiction of what's going on here?
That is an accurate depiction. He would submit the credit request to Bank of the West, and there would be a credit approval from, in this instance, Bank of the West prior to entering into all of these agreements.
Okay, so this isn't like Rooms to Go where you walk in and go, okay, I'm going to buy a couch for $1,000, and they go, sure, you're approved, and then they go out and sell the paper to get financing for it. You all already have a relationship, and they know at that point who's financing. And Mr. Benavides knew at that point who was financing when he signed an agreement that said, I'm going to be looking to them, and that's who I'm dealing with.
Before you answer,
that's not the
is all this in the
agreement
complaint? Because we're here on a motion to dismiss.
Right.
Is all this business transactions what they knew in the complaint filed by the plaintiff? Or does that have to be discovered later on? Because we are here on an order on a motion to dismiss, right?
Right. So
right.
what
I'm
we have,
looking at 4 quarters of the plaintiff's complaint.
And the point I was trying to make is all of that may factually be the scenario, but the legal documents The contracts that these people signed did not obligate them to proceed that way and did not obligate the the seller to assign this to Bank of the West. The documents were between the seller and the buyer, and then the seller did assign to the Bank of the West. And that could have been preordained, but that's not what the legal requirements were. Correct?
You are correct. Yes.
Okay.
Yes. And yes. So as far as the documents are concerned for a motion to dismiss, we have the purchase agreement, which outlines everything I've discussed. And then we have the finance agreement, which is how Your Honor portrayed it. It is an agreement that was originally signed by General RV, however, immediately assigned to Bank of the West.
But that assignment, I think you will agree, does not determine this legal dispute about the merger clause and which agreement is the operative one.
That assignment does not. You're correct.
Right.
I think the documents themselves are what determine their roles. And we have a purchase agreement that says, I agree to purchase. And then we have a finance agreement that says, I agree to pay. The only reason it has to mention the sales terms is because first, it has to comply with TILA. It has to give all of these charges that he's paying that are being financed. And second, the ultimate financer, which was ultimately Bank of the West, needs to protect their rights in this case. Because it's, like I said, it's not just an installment contract, it's a retail installment contract and security agreement. So all of those descriptions afterwards of the equipment of the RV that's being purchased are required so that ultimately the bank can protect its interest in the event of a default. So we have two separate documents governing two separate transactions, one the purchase, one the finance. And that's what the court determined, is that we have a document governing the purchase and we have a document governing the finance. And the plaintiff relies heavily on the Duval case. And I think it's really the most important distinguishing characteristic of that Duval case is the purchase agreement in the Duval case was not necessarily a purchase agreement. The court said that it was just an order. So it wasn't this agreement to purchase. It was more so, this is what I want, this is the price it's going to be. It wasn't, I promise to buy this from you in exchange for X number of dollars. It was literally just a purchase order. So in this case, we don't have that. We have what is abundantly clear is a purchase agreement. It says purchase agreement. It describes the relationship. It tells the obligations of the parties. It describes the difference between itself and the retail installment contract. So we clearly have a purchase agreement. So the Duval holding wouldn't apply in this case. And I agree that with the other case, the
Lowe's.
Thank you. Lowe's versus Nissan has some distinguishing characteristics as well, but it's more akin to this. It's not right on point. There is no case right on point. Otherwise, we wouldn't be before you, and this would be a really easy decision. But that Lowe case is more representative of this because you have the interplay between these separate documents. We actually have a purchase agreement in this Lowe case. So then it becomes more like what we have before you today. And in fact, the Lowe holding is the purchase agreement merger clause states that the purchase agreement comprises the entire agreement affecting the sale. The purchase agreement is the operative document governing the entire sale. And so that's what we have here. We have this purchase agreement that governs the entire sale, and it says so. And it explicitly says this does not govern the financing. And then we have a separate document that governs the financing. And so,
well, but that may be true. But the even if that was true, the purchaser's argument that then the financing document had a merger clause that made it the operative document on the sale, your argument didn't work the other way.
But we don't
I
have.
get what you're saying, but you're right at the end of your 20 minutes because I very helped you use that time. But I'm always glad to be of help. But
thank you, I appreciate it.
My colleagues can attest. But I have the one question for you, and that has to do with the form of this order, which says that it is the clarifying order says the dismissal was with prejudice as to general. In Florida, dismissal with prejudice is deemed to be a determination on the merits for purposes of res judicata. So do you agree with Mr. Bolger that he could still go to Michigan and file a lawsuit on behalf of his clients?
I would love to say no, but my impression being before the trial court was that he is dismissing it with prejudice in his court and that the plaintiff is free to pursue his rights in Michigan.
Okay. I mean, certainly the document doesn't say that, but that's what the intention was.
That was, I don't want to say that was the intention, but that was my impression. And I believe it was Mr. Bolger's impression as well.
Well, certainly if that wasn't the intention, that would be error, right?
Right.
Right. Okay.
Right.
All right.
If I may just leave you, I think the trial court, in 1 second to just bring everything to a conclusion, I think the trial court order actually put it best in its order when it said to agree with the plaintiff would require the court to disregard all provisions of the purchase agreement. Such action would be devoid of reality and sensibility. For example, does plaintiff's counsel truly believe that the dealer was knowingly, intentionally waiving all exclusion of warranty provisions it negotiated in the purchase agreement so that Bank of the West could finance the subject RV? Of course not. And I just want to leave you with that because I think it's really telling, and the repercussions of ruling otherwise will literally turn the dealer buyer relationships on their head. So thank you very much for your time. I appreciate it.
Yep. Yeah, you're quite welcome. Okay, Mr. Bolger, you have your 5-minute rebuttal.
Thank you, Your Honor. Okay, I'm going to take it back to the rule of law because the rule of law starts with this, and the rule of law is announced by this court in Lowe v. Nissan of Brandon. It's also announced in Triple H Motors LLP versus Holt. It's also mentioned in Duval Motors v. Rogers and also Bird Lakes Development v. Marullo. So all the DCAs seem to agree that ordinarily documents executed in a sales transaction are construed together. So the trial court had the right to say, I'm not going to follow the merger clause. I'm not going to blindly follow it. That's what the trial court seemed to do in its order. But if it was going to do that, it was then incumbent upon the trial court to construe all the documents together, including the retail installment sales contract, which specifically has a Florida law provision and allows for a suit in the venue. So that's going to conflict with the purchase agreement and these other documents that state Michigan law. So you can't have it both ways. Either you have to respect the merger clause in a retail installment sales contract, or then you have to construe them all together. But what they've done now in this case is that they've created this new bright line rule, apparently that when you have a retail installment sales contract and you have a purchase agreement, and they both contain merger clauses, you now can say that there's two separate transactions and you can completely ignore the retail installment sales contract. So I think that's the error there. And the only other thing I want to spend a little bit more time on is, and the appellees touched on it, and so I don't want to get far afield, but there is an express warranty by a manufacturer. However, that warranty wants venue to be in Indiana. Now you have the appellee who wants venue to be in Michigan, and then you have a retail installment contract that says Florida law is supposed to be applicable. So really, if you look at this, it's really unfair on the appellant because no matter where you go, you're going to have some party saying that you're not where you're supposed to be, and really they want to create an orphan out of the case. So I want to circle back because as the court pointed out, the Carrick case is what the trial court relied upon for not saying that the venue provision is unenforceable because it deprives a day in court, it's unfair or unreasonable or the product of overreaching. And that Carrick case relies exclusively on business-to-business transactions. So the trial court never addressed the differentiation between the Krenzel v. Kirchner case, the MS Bremen and Unterweser GmbH v. Zapata case, the Manrique versus Fabry case, or the Guardsmark security case. All those cases stand for the proposition that if you're going to send somebody to legal Siberia where there's absolutely no witnesses, no documents, the actual RV is not there, then the trial court or this court should look behind that venue provision to see if it's really unfair or not. The venue provision in this case, and there was an affidavit supplied, shows that none of these witnesses are in Michigan or can be compelled in Michigan. They also show that the plaintiff has an autistic child that can't travel. The reason why they bought the RV in the first place is because the child can't be taken to unfamiliar places like hotels or commercial transport, and they wanted to acclimate the child to the RV so they could travel with it. So they can't afford to travel there. They can't travel with their child. The RV is not drivable and safe to drive, so it can't be taken to Michigan, and none of the witnesses can be compelled to Michigan. Now, this venue provision was in an adhesion, take it or leave it contract. So there's no real bargaining power by a lay person like the plaintiff in this case to bargain and try to take that out. And so those cases should at least been considered by the trial court. They weren't considered, and nobody's addressed them in response to this appeal either. All that's been quoted is the business-to-business cases where you have a legally sophisticated corporation.
Well, Keurig was not a business-to-business case, that case itself, correct? That there were individuals involved in that case.
You're right, Your Honor, but I'm saying the case law that they relied upon in that.
I get that.
Yeah, and Keurig was a federal trial court,
right?
Basically, and all they've done in this appeal and below is reference other trial court orders. There's no precedent, and basically what they've done is ignored all this precedent, saying that business versus consumer are different. It's a different standard. You have to look behind the venue provision to see if it's fair or not. That's all I'm saying. And thank you for everyone's time.
Thank you both very much. In order to leave our virtual courtroom, you need to click the leave button in the lower right-hand corner of your Zoom screen, and then you'll be gone. And we'll call the next case.
Thank you very much for your time. I appreciate it.
Sure.